Welcome to How to Avoid Sinking Your Civil Appeal Before It Sets Sail. I'm Belinda McCauley, Executive Director and CEO of the Beverly Hills Bar Association. I am delighted to be here today to introduce our speaker, Brendan Begley. Brendan is a shareholder at Weintraub Tobin and a certified appellate law specialist who has served as lead counsel in more than 70 appellate matters, including cases before the California Supreme Court, Ninth Circuit, and U.S. Supreme Court. He brings extensive experience across complex civil litigation, class actions, and appellate advocacy, with multiple published decisions and a successful certiorari grant in the landmark Elk Grove United School District versus Nadeau case. And now let's get started.
Thank you, Belinda, for that very kind introduction. And thank you, everyone, for joining me today. If you haven't already seen, you'll quickly see that my presentation today has a bit of a nautical theme to it. And so I've included some clips from different popular films just to try to kind of as a memory aid. If I think you see these things, it will help you remember these somewhat dull and boring appellate concepts. It kind of spices them up a little bit and makes it easier to remember these important things that you need to practice. And so since it has a theme, it just seemed to me it should have a suitable opening, just like every successful presentation has had since the old TV series Batman and Mission Impossible, all the way to the more recent Mad Men and Game of Thrones, I guess. So Susie, if you would advance to the next slide, and let's play the beginning theme.
Just sit right back and you'll hear a tale of a fateful trip that started from this tropic port aboard this tiny ship.
All right, Susie, next slide, please. Now, everyone. Oh, sorry, there we go. I don't want you to wind up like the SS Minnow on Gilligan's Island in your appeal. Okay, you don't want to be stuck somewhere that you can't get the reversal that you need. So we're going to talk about the ways not to sink your appeal, like Gilligan and the skipper and the storm sunk the minnow on Gilligan's Island. So there are 6 steps, and just to kind of give you an idea of what they are. The first step is to make sure your potential appeal is seaworthy by recognizing appealable orders. So we're going to spend a little time talking about what is appealable and what's not appealable, because if you miss something that is appealable, you're not going to be able to resurrect it later. It's going to be on the bottom of the ocean. You won't be able to pull it up. Second step is to enhance their ability to keep afloat by getting a court reporter. Sometimes you can't, and if you can't, you're going to have to deal with some struggles, and we're going to talk about the struggles. And once you see them, I think you're going to be very, what would be the word, encouraged to do everything you can to get a court reporter. The third step we're going to talk about today is to reduce the risk of being capsized by getting a statement of decision. It can be tricky here too. Sometimes you think you already got one, and so you don't need to ask for it. Sometimes you might think all I need to do is ask for it, and that's it. There's more to it than that. Fourth step we're going to talk about is making sure you can leave the harbor by timely filing a notice of appeal. You got to get that notice of appeal filed. That goes hand in hand with the first step of recognizing an appealable order. So we're going to talk about the deadlines. Although that can be complicated, I've got a really neat trick to make it very easy. And then the fifth step is you want to help the appellate court to track your course of your nautical journey, if you will, by designating a proper appellate record. Another way to say this is you want them to be able to hear what happened in the trial court by giving them a proper appellate record. And so we're talking about the different options there and what I would recommend. And then sixth, the last step, you have to avoid getting torpedoed. If you misunderstand how appellate stays apply, it can create a lot of friction between you and your client. We're going to see a lot about that when we get to it. So those are the 6 steps we're going to talk about. Let's go to step 1. And Susie, if you would, play this slide for us. No, I'm sorry, Susie. Advance from this slide. I apologize. We're going to skip this one because we want to make sure we get that on time. So the next one, please. Next slide, please. There, let's play this one.
Mr. Hooper, I'm not talking about pleasure boating or day sailing. I'm talking about working for a living. I'm talking about sharking.
Well, I'm not talking about hooking some poor dogfish or sand shark. I'm talking about finding a great white.
Orcas, talking about Porkers, Mr. Hooper. Just tie me a sheep shank.
All right, next slide, please, Susie. Folks,
Hooper,
I'm not
I'm-
talking about unappealable orders. I'm talking about appealable orders here. You need to recognize the appealable ones. You don't want the dog, fish, or whatever he says, whatever Quint says. You want the porkers. You want the real appealable judgment or order. Now, you have to be able to distinguish. You have to be able to know what's appealable and what's not. The list of unappealable orders is going to be way too long for us to talk about. So we're going to kind of focus on what is appealable. You know, you don't want to waste time appealing from an unappealable order. You're going to you're going to run up your client's fees and lead to a lot of frustration if you're doing that. But more importantly, you definitely don't want to miss the great white shark out there. You do not want to miss an appealable order because, as I'll tell you later, if you overlook it and you don't appeal from it, your deadline to appeal will have passed, and when you get a different appealable judgment order, you're not going to be able to resurrect that prior one. You will have lost the ability to change a bad decision. So the list of appealable orders is about 14 or 15 of them. The unabridged, this is an abridged version that I have on the slideshow. I have an unabridged version in the handout. And so there's only a few things you need to recognize. The first two are pretty easy to see. A judgment, a final judgment. The case is done, that's it, final judgment. That's going to be appealable just about every time. There's almost no exception to that. And then also sometimes there's an order that comes after a judgment. Think of like a motion for attorney fees if you have an employment case or a contract case where there's a shifting fees provision. And so you get the judgment, and then after the judgment, you have a post-judgment motion for fees. That post-judgment for fees is also appealable. It doesn't mean that everything that happens after a judgment is appealable. It sort of has to be a final order. So if you have a judgment, somebody files a motion for fees, and then somebody else files a motion to, continue that motion for fees. The motion for continuance, if granted, is not going to be an appealable post-judgment order. It sort of has to have its own level of finality. Next slide, please, Susie. Other common ones would be an order granting or dissolving, or even refusing to grant or dissolve an injunction. Anytime there's some sort of injunctive relief, red alert should be going off. I'm looking at an appealable order here. You ask for an injunction, the court says no, appeal. The other side asks for an injunction and gets it, appeal, okay? So this is important. Also, orders made appealable under the probate code and the family code. They are way too numerous for us to cover in this basic presentation. I do sometimes specialized appeals in probate and specialized appeals in family law cases, and then I will talk in those presentations about all those different kinds of orders. But if you're doing family law or probate law, you need to know there are quite a few appealable orders and they're specified in the codes. The probate code, I remember, they're like between 1300 and 1310 of the probate code. Appealable family law orders are sort of scattered around in different statutes and in case law. Also, an order directing a payment of monetary sanctions over $5,000. Hopefully that's not too common in your experience, but being an appellate practitioner, I do see that happen. So that is an appealable order. And also, orders granting or denying special motions to strike under section 424.16 of the Code of Civil Procedure. SLAP appeals have mushroomed over the last 25 years. They consume a big part of the court's docket. So if you're in the SLAP case, you need to know that you're probably looking at an appealable order as soon as the court grants or denies or partially grants or partially denies the anti-SLAP ruling. Funny quirk with anti-SLAP, there's a split among the different courts of appeal in California as to whether the order that comes after that, awarding fees or denying a request for fees, is separately appealable. Some courts say yes, some courts say no. So if you're doing anti-SLAP, which I do a lot of, keep that in mind. Next slide, please. Okay, so the second step is you're going to have to recognize and appreciate the need for a court reporter. And let me tell you why. The appellate court simply cannot hear what was said in the trial court without either a reporter's transcript or its very poor alternatives, an agreed statement or a settled statement. And so let me just play this little clip in our next slide so that you kind of get an idea what I'm talking about.
Can you hear the jack whales singing?
Beautiful. I wonder what they're saying.
Well, that was the sludge tanker over there, but there you go.
Okay, so next slide, please,
Can you-
Susie. Here's the thing that Bill Murray, I think, is illustrating for us is that, if you don't have a reporter's transcript and you use one of these alternatives, an agreed statement or a settled statement, a whale song that was played in court is going to sound like a sludge tanker. It's going to come out distorted and different than what you might have remembered it to be. So an agreed statement, as my slide says, the rule that governs it is 8.134, and there's an abridged version of that in your handout materials. An agreed statement, I don't think they really exist. Finding one, as my slide says, may be more difficult than finding a unicorn under the waves of the ocean. I've heard about them. I've never really seen one because you know what you have to do? You have to agree with opposing counsel about what was said, about what the questions and answers were from the witness, on the stand. And you're never going to agree about that. Your memories are going to be different. And so I've seen people try this step and then it fails, and then you have to come back and you have to redesignate the record. And so you've expended, a lot of effort and run up a bill for your client, and it usually doesn't lead to anywhere good. The alternative is not much better. It does exist. It's a settled statement. A settled statement is where you and opposing counsel cannot agree, which is you can expect that, about what was actually said. And so you propose one version as the appellant to the trial court, the judge who presided over the case, and the other side presents their version of what happened, and the trial judge settles the statement. Now, listen, if you just take a little spin through your handout, you're going to see all kinds of complications with this. I mean, you have to do a proposed statement, and the good news is the judicial council has created a judicial council form to help you do this, because otherwise you're just making it out of, you're making it from scratch. But this form can help navigate what you need to do, and you check the boxes and you fill in the information, and it kind of is a good assistance for preparing a proposed settled statement. Then the other side is a judicial council form for the other side to use to say, no, that's not really happened, what really happened. And then you both submit your forms to the trial court. Well, then all kinds of deadlines get triggered, and you can ask for a hearing, but the trial court doesn't necessarily have to give you one. And then the trial court issues its modified or corrected settled statement. And then you got time, both sides can object to that and maybe even propose further modifications. And then you kind of run around it again until the trial court says, I've had enough. I had one case like this recently. We started the proposed because we didn't have a court reporter. We won. The other side appealed. They didn't have a court reporter. They opted for a settled statement. We had 6 hearings on this. 6 hearings on this over the course of about 7 months. Each hearing was between a half hour and an hour. Not only that, but beyond the hearings, both sides were spending all kinds of time. The lawyers were trying to figure out what was really said and how to articulate it in the best light and whatnot, and how to object to what the other side is saying. A court reporter's transcript is going to be a lot cheaper. Trust me, it's going to be a lot cheaper, and usually it's going to be a lot faster. It's going to expedite your appeal. So you're really going to want to see if you can get that. Next slide, please, Susie. Okay, I'm hoping I've convinced you about how you really need a reporter's transcript and how you really need to be able to spot those appealable orders and judgments. And the next thing is just as important. I mean it. You're going to have to get a statement of decision. And so I have a little bit of footage to share with you that sort of is a representation of what an appellate lawyer will see and say to you if you call and say, I want to appeal, but I didn't ask for a statement of decision properly. Susie, can you play the clip in the next slide, please?
You're gonna need a bigger boat.
Okay, next slide, please, Susie. Yeah, you're going to need a bigger boat. So a statement of decision is a little more tricky than any of the other 2 steps that I told you about. I mean, step 1, You just go to 904.1A of the Code of Civil Procedure and you go down the list to see if you've got an appealable judgment or order. Unless you're in a family law or probate case, then you got to take a couple other steps. Step one is pretty easy. Do I have an appealable order or not? Step two, call a court reporter. It might take a little effort. You might have to make a few calls because there's kind of a shortage now, but that's not that hard. It's a lot harder to do the alternatives, as I've tried to illustrate. Step three is trickier than the first two steps. It seems easier, but it's not. It seems like you should just ask for a statement of decision, and it might even seem to you that the judge already gave you one, so you don't even have to ask. Nonsense. Please don't fall into this trap door. I'll be telling you when you call me, you're going to need a bigger boat because this shark just ate your appeal. So the two rules that you need to know about, well, the two authorities you need to know about primarily are Section 632 of the Code of Civil Procedure and Rule 3.1590 of the California Rules of Court. Now, listen, as you can see in this caution, which I'm embarrassed I have a misspelling in there, it's not dead liens, it's dead lines, and procedures that I'm talking about today are only effective through December 31st of this year. After that, they're going to change. It has mostly to do with timing. And you'll come back to my presentation and watch my movie clips next year, okay? When the changes come about, and I'll tell you about them then. But for now, you just need to know how to do things this year. Now, this year, when you have a bench trial, the trial court is supposed to issue a tentative ruling. And upon the request of a party, it will issue a statement of decision. Look, it's upon the request. It doesn't have to. It just has to issue a tentative ruling. It can do it on the record from the bench orally at the end of, once the case has been submitted, or it can do it in a written tentative decision. Sometimes the courts call these tentative decisions proposed statements of decision. Sometimes they call them tentative rulings. Sometimes they just call them statement of decision. All three of those things are kind of misleading, except for tentative ruling. I'm sorry, tentative ruling is not misleading. Proposed statement of decision and statement of decision is a little bit misleading. I'm not saying the courts are deliberately misleading you. I'm just saying that those titles are somewhat misleading. Now, you have to make your request for a statement of decision within 10 days after the court announces its tentative decision, unless the trial was less than 8 hours in one day, or 2 days, but still less than 8 hours, or 3 days and less than 8 hours. The trial's less than 8 hours, 1, 2, or however many days. Then the trial court, then you have to request your statement of decision before you submit and before you get the trial court's ruling. Now, here's the thing, this part that I've highlighted in blue, the request for a statement of decision shall, not should, not maybe, not, well, the best ones do. No, it's shall specify those controverted issues to which a party is requesting a statement of decision. You have to list the principal controverted issues in your request for a statement of decision, or else, in my opinion, your statement of decision is defective and you haven't asked for a statement of decision. And if you don't ask for a statement of decision, that leads to the imposition of this thing called the doctrine of implied findings. And so even though in the court's tentative decision, which has been labeled maybe as a proposed statement of decision or even as a statement of decision, the trial court left out findings on vital factors that had to be, there has to be a finding on this. Well, if you don't ask for a statement of decision and list that factor as a principal controverted issue, the Court of Appeal is going to infer that the trial court made the necessary factual findings to support that, ultimate decision, even though they are not listed in the proposed statement of decision, in the so-called statement of decision, in the actual tentative ruling. Susie, can I have the next slide, please? So, it's not really misleading for the court to call it these things because the rule more or less says that it can do it. These common provisions are authorized. It can say that it's the court's proposed statement of decision subject to objections under 3.1590G, or it can direct that a tentative decision will become the statement of decision unless a party specifies those principal controverted issues, which I'm telling you to do, which a party is requesting in a statement of decision. Now, the timing to request a statement of decision, as I've already said, is 10 days after the announcement of the tentative ruling. If a tentative ruling comes out and it says statement of decision, and there was no tentative ruling before, that statement of decision is a tentative ruling. You have 10 days from then to request a statement of decision and list the principal controverted issues. You can be easily misled by thinking it says right here that I have 15 days under subpart G to make my objections. That's to make objections. Objections are different than requesting a statement of decision and listing the principal controverted issues. You can do both in one. You can request a statement of decision, list the principal controverted issues, and then add objections under subpart G of Rule 3.1590 and say, here's why I'm objecting to the court's tentative decision. And you can do it in reverse order. You can say, here are my objections, and in addition, I'm requesting a statement of decision, and here are the principal controverted issues that I think the statement of decision needs to address. You can do both of them together. You can do it separately, but I'd say make sure you do it within the 10-day deadline. Susan, can I see the next slide, please? It's a little bit duplicative here, but the first bullet point is the thing I really want to drive home. The tentative decision does not constitute a judgment, and it is not binding on the court, regardless of how the court labeled it. If it labeled it as a tentative, if it labeled it as a proposed, if it accidentally labeled it as an actual statement of decision before any tentative came out, that's still a tentative. You can still challenge that by requesting a statement of decision and listing the principal controverted issues, and if you like, objecting under subpart G. Can I have the next slide, Susie? Now, as you can see in my last bullet point here, the court may, by written order, extend any of the times prescribed by this rule. And, if good cause is shown, it can excuse your tardiness. It can do that. Most courts are not going to be thrilled about doing this. Sometimes there's good reason. And if you ask the court at the beginning, at the outset, hey, we want a little more time to do these things, will the court let us do it? Yeah, generally the court might go along with that. But if you've already missed your deadline to request a statement of decision, and you're the one that's looking like it's going to appeal, I mean, a judge might grant you it, but I just don't see a judge having a lot of incentive to help you tell the Court of Appeal that he or she is not fit to be the dog catcher because they got your case so wrong. Now, I know that's not really what you would say, and judges get it wrong. They're still fit to be judges. We're all human beings. I'm not disparaging judges here. I'm just saying there's not a lot of incentive to help you, tell the Court of Appeal that the judge was bad. And judges are busy. So, you know what, if you're already late, they might think, look, you should have done this. Why didn't you go to Brendan's seminar? He would have told you, you got to get this done. And so, I've got a lot of business on my plate. That was your mistake. I'm not going to give you the extension of time. So you have to request a statement of decision. I know I'm repeating myself. Everybody in my family and everybody I've ever dated, they all tell me, you say things at least 3 times. Well, it's because I really want you to make sure you get it. Request that statement of decision. Don't be fooled by the tentative ruling being labeled as something else. Not only request a statement of decision, but list, this is critical, list the principal controverted issues in your request for a statement of decision. Next slide, please, Susie. Now, once you request a statement of decision and triggers deadlines, the trial court then has 30 days from the announcement of the tentative decision to prepare a proposed statement of decision. It can also direct the parties to do that. If you're the one asking for the statement of decision and you're the one that the bench trial went against, likely the court is not going to ask you or direct you to prepare the proposed statement of decision. Likely it's going to be the other attorney. And, after the proposed statement of decision then comes out, then you have 15 more days to list objections. If a new proposed statement of decision comes out, you have 15 days. Sometimes after you've already requested a statement of decision and made your objections to the proposed statement of decision, which could have been labeled, like I said, a tentative or an actual statement of decision, well, then the court can just issue its final statement of decision and there's no more objections. You're done at that point, and that's okay. Listen, if you take these steps, very slight possibility you'll have a light bulb go on for the trial court, and the trial court will see, oh, you know what? I didn't think that one through. I'm going to reverse myself and I'm going to give judgment in your favor instead of the other side's favor. That doesn't happen a lot, but it can happen. But even if it doesn't, the critical thing is you've preserved your issues for appeal. You're not going to get dinged by the doctrine of implied findings. Okay, so next slide, please, Susie. Now, it's very, very important to file a timely notice of appeal. And I've borrowed a little footage of what approaching and missing this deadline will look like and feel like. So Susie, if you can play the clip on the next slide, please. Okay, Susie, next slide. Yes, if you miss the deadline to file your notice of appeal, you and your client are going to feel like you're on the Titanic, like you were on the Titanic, with maybe two differences. One, I can't remember how many hours it took the Titanic to sink. Your appeal is going to sink just a little bit more slowly, which is going to be actually more excruciating because the Court of Appeal will probably issue an order to show cause, telling you to explain why they shouldn't dismiss your appeal from being from an unappealable order. I'm sorry, from being untimely, or which, then it's going to drag it out for, 10 days, 2 weeks, 3 weeks, whatever. So you're sitting there waiting and you're realizing I missed the deadline and there's not much I can say about it and there's no remedy for that. That's number one. It's going to be a little slower than the Titanic. Number two, there won't be any lifeboats. Okay. There are no lifeboats if you miss the deadline to file your notice of appeal. You're not going to be able to file a 473 motion and say it's excusable neglect and fall on your sword. You're not going to be able to find some kind of case that says this gets told because of whatever. There's no lifeboat. If you miss the deadline to file your notice of appeal, you're done. The rule that sets it forth, and this is in the handout, 8.104 of the California Rules of Court. And, this sets forth the timeliness. And normally the deadline is going to be 60 days. There are times where it's 60 days plus, and then there are times where it's 180 days. And, all right, so it already sounds kind of confusing. Like I said, I got a simple rule that's going to help you avoid all this complication. The other complicating factor is you might think that there's this exception in Rule 8.66, because it's a public emergency. I got in a car accident that day and I wasn't able to get to the Court of Appeal. I'm sorry, to the trial court to file my notice of appeal. Or, my kid got kicked out of school and I had to go talk to the principal. I mean, these are emergencies. They're not public emergencies. Okay, so Rule 8.66 is not going to help you. Those are not public emergencies. Destruction or danger to a building or the housing where a reviewing court sits. Absent one of these things, no court can extend the time to file a notice of appeal. There's no lifeboat there for you. So if you file an appeal late, like this says, the reviewing court must dismiss the appeal. Now, for 20 years of my practice, we never ever saw such a public emergency. The pandemic was one, so we do have a recent one. And but you know what? It's not likely we'll see another one while I'm still practicing. I shouldn't say. I hope we don't see another one while I'm still practicing. But in our lifetimes, I think we've all sort of really just experienced one. So that's how rare a public emergency is. You're not going to get extra time for that. Now, there is one other little thing that the reviewing court can treat a notice of appeal as a writ petition if it wants to, but not a late filed appeal. So there again, there's no lifeboat there. Sometimes if you appeal from an unappealable order, the Court of Appeal can save you and they can say, well, we're just going to treat this as a writ petition and then we're going to do appellate review on that basis. But if you file a late notice of appeal, they don't have that discretion. They can't do that. Now, if you file an early notice of appeal, no big deal usually. The reviewing court can treat a notice of appeal that was filed prematurely as an appeal from the final judgment. I don't want to encourage you to do that, though. You really want to figure out when your appealable order happens and then appeal from it within the deadline. Summary judgment is a good example. An order granting a summary judgment motion is not appealable. You have to wait for the judgment that comes later. In a lot of appellate courts, if you appeal from the order, I shouldn't say a lot, in some appellate courts, if you appeal from the order granting summary judgment, and then later on the actual judgment comes out, the Court of Appeal can save your appeal by saying that your notice of appeal, construing it as though it was from the final judgment. I know for sure the third appellate district does not do that anymore. I have a recollection that the second appellate district, at least certain divisions of it, will not do that. And so some courts still might. I just say, don't try to file it early. Look for and make sure you have an appealable order and then calendar your deadline from that. If an order for summary judgment comes out, turn to Rule 904.1, I'm sorry, Section 904.1A of the California Code of Civil Procedure and see if that's appealable. If it's not, sit and wait. But then when the judgment comes out, there it is, 904.1A1. I got a judgment. I'm going to appeal. Now, what did that guy who looks like Conan O'Brien said about the deadlines? He said they were kind of tricky. There's 60-day, there's a 60-day plus, there's a 180-day. The 60 days is if the court issues a notice of appeal, issues a ruling that has a proof of service showing that it was served to you, or if any of the parties issues a notice of entry of judgment or order. And then the proof of service starts the 60 days ticking. So 60 days from the judgment, if the court attaches a proof of service saying, here, I've served the judgment. A week later, somebody else issues a notice of entry. Well, that's not going to extend it. You don't get the 60 days plus because there was a proof of service with the original judgment. That's when the 60 days starts running. If the court issues a judgment without that proof of service, a week later, somebody issues a notice of entry of judgment or order with a proof of service, you get the 60 days plus. It's not 60 days from the judgment, it's 60 days from the notice of entry. So you got a little more than 60 days from the judgment. If you calendar it, here's the trick. If you calendar it 60 days from when that judgment comes out, regardless of whether there's a proof of service, regardless of whether there's a notice of entry, you're going to be okay. You're going to be safe. The last fallback this option is a 180-day deadline. That's if the trial court issues a judgment or order without a proof of service or notice of entry. Nobody else issues a notice of entry. Then you have 180 days from the judgment. You should only be thinking about that 180 days if through some wild accident you forgot to calendar the 60-day deadline that I told you about, and now you're scrambling to see if there's some way you can still save it. If anybody issued a notice of entry with a proof of service, that 180-day deadline is a fiction. It doesn't exist. So 60 days from the actual court's entry of the judgment. That's not what the rule says, but if you do it that way, you're going to be safe. If you do it the other ways, you're getting into complexities and ifs, ands, or buts, and just 60 days. Tell yourself I'm going to do it 60 days from when the judgment came out. So you can have the next slide. Now, listen, if you want to appeal and the other side appeals before you, you get a little bit of extra time there. It's, sorry, did I skip a slide? Sorry, prior slide, Susie. Maybe it comes later. All right. Well, I'll tell you if, oh, no, sorry, here, extension time for cross appeal. If the appellant timely appeals a judgment or appealable order, the time for any other party gets extended by 20 days. And so this prevents gamesmanship where, you're thinking about appealing, but maybe you'll let it go if the other side doesn't appeal. And they're thinking the same thing, but they wait until the 60th day. And then they wait till 4 o'clock that afternoon and they have a courier standing there at the trial court and they file their notice of appeal and now your 60 days have gone by kaput. Well, no, if they do that, you get 20 more days, okay? You get 20 more days. But if they file their notice of appeal on day 10, you don't get the 20-day extra time at the end of your 60 days. You only get 60 days. Okay, you only get that 20 extra days if they're filing it in a way that, beyond the 40 days, if you will. Actually, even further beyond that. So you get that little bit extra time to file your appeal. And Susie, I'm sorry, can we go back to the slide about Rule 8.104? I think it's the 21st slide. Yeah, there we go. All right, yeah, I did cover that slide. I want to talk about tolling motions. Oh, there we go. Yeah, next slide, slide 22, Rule 8.108. There are tolling motions, and they are listed in your handout. It's Rule 8.108 of the California Rules of Court. And I just have a gander at them, and the slideshow doesn't indicate what they are, but they are in your handout. So I'm not leaving you stranded on a desert island. And so a motion for new trial will be a tolling motion. So will a motion to vacate the judgment. So will a motion for judgment notwithstanding the verdict. So will a motion to reconsider an appealable order. And public entity actions under a certain section of the government, certain sections of the government code are also, they get a little extra time. So if you represent a public entity, you want to know about, government code sections 962, 984, and 985. But otherwise, you want to think about these other motions. These post-judgment motions can toll your deadline to file a notice of appeal, and then the deadline will get triggered depending on various outcomes of those motions. And so I just want to pause to mention one little tricky thing, though. A motion for reconsideration. In federal court, you can ask for reconsideration for just about anything. Okay, the dog ate my homework, even. But in state court, which is what I'm talking about here, I'm not talking about federal appeals. All this presentation is about your California state law appeal. A motion for reconsideration, it can only be limited to like discovery of new facts or new law coming out in the interim. And so if your motion isn't based on one of those things, it's an invalid motion for reconsideration, and therefore an invalid motion does not toll the deadline to file a notice of appeal. So if you're going to do a motion for reconsideration, be very careful about it and make sure you are doing it under one of the statutorily permitted bases for asking for reconsideration. And I would say that probably applies also to a motion for a new trial, motion for judgment notwithstanding the verdict. I've not seen appellate decisions on those. I've seen one about reconsideration where it wasn't a valid motion, so it didn't toll. So you got to make sure that these motions are valid. Don't just file them to think you're going to buy extra time. If they're not valid, they're not going to get you the extra time you're hoping. Okay, now next slide, Susie. That's the extension of time for the cross appeal that I've already covered. You get the 20 extra days. So next slide, please, Susie. Step 5, you're going to have to designate a proper record. I've already talked about getting your court reporter, so hopefully you've remembered that and you've designated the court reporter. Now, designating a record, it's a judicial counsel form. It's a check the box form. It's a few pages. I think it's 4 pages. There's a lot of information to include. There's also a lot of information to leave out of it. And so in that sense, it takes timing and precision, I'd say, to designate the appellate record. You have to think about what you really need and how to get it. Now, this timing and precision is a little bit like turning a submarine away from a fatal torpedo impact. And, you have to do it at exactly the right moment and exactly the right way. And so, Susie, if you'll play this next clip, I think it really hits that home.
30 seconds. Turn it massive in 7, 6, 5, 4, 3, 2, 1, mark. Torpedo impact, 25 seconds.
Right full rudder, reverse starboard engine.
Right full rudder, hold back starboard shaft.
Hold back starboard shaft.
Torpedo impact, 12 seconds. 10, 9,
Okay, so as you can see, not all my slides are doom and gloom. This one shows how, if you designate that appellate record the right way at the right time, you can avoid this impact. So happy ending for that one, right? Now, I've given you a link here on the slide and also in your handouts to the Judicial Council form to fill out, what you need to designate the appellate record. Now, I'm going to tell you there are two parts to the appellate record, basically. One is everything in writing that was filed in the trial court, and two is the oral things that were said in trial court. Now, part two, the second component is the reporter's transcript, okay? Or if you didn't get one, the, fictional agreed statement or the really aggravating settled statement, aggravating and expensive, I would say, settled statement. So that's the oral proceedings. You're going to have to designate them, but let's talk about the paper proceeding, the paper that got filed in the trial court that you need to designate. You're going to see on this form, if you click the link and it's a fillable form, that you can designate sort of three different things. One, a clerk's transcript. When I started practicing 25 years ago, that was still probably the most common thing to see for the appellate record is a clerk's transcript. You tell the trial court clerk all the things you want to include in the appellate record. He or she runs around, gathers them all up, puts them in chronological order, and arranges them in different volumes of 300 pages each, and then sends a copy to you and sends a copy to the opponent and sends a copy to the Court of Appeal. That can be time consuming. The other option, which I want to tell all you lawyers never to use, is just to opt for the entire Superior Court file. And so the clerk will then, instead of having to run around and find the specific things you asked for, he or she is just going to box up everything and ship it over to the Court of Appeal. Sounds great, right? That sounds really easy. Then you're sure you're not going to leave anything out. No, that's actually an epic fail. That is an epic fail because when you write your brief, you're going to be citing to something and you're going to require the staff attorney and the appellate court justices who are handling your appeal to wade into an ocean of all kinds of stuff with, eddies and whirlpools and sharks and waves and whatnot to misguide them and mislead them. And you're going to make it really hard for them to find what you need to show to them to prove that there was error in the trial court. It's going to aggravate them. And it's going to increase the risk of human error. I wouldn't say a court would ever deliberately overlook something you cite because they don't want to go look for it. But listen, we're all human. We all make mistakes. There's a fair chance that they're going to go look for it and they're not going to find it because it's not organized very well. The trial court sent boxes and who knows how they organized them. They're probably not going to be in chronological order. They might be discovery motions in one box and dispositive hearings in another box and jury instructions in a different one. It's going to be all over the place. So don't use that. Listen, it's a multi-syllable word, appendix. There's 3 syllables to it, but that's the other option. Don't be scared by 3 syllables and by the fact that maybe you've never done an appendix. There are attorney services out there that will prepare an appendix for you and show you how to do it. Paralegals can easily learn how to do it. Heck, I have a secretary. She's brilliant. She does all of mine. So an appendix is where you prepare your own clerk's transcript, basically. You have to do it in chronological order. It used to have to be 300 pages per volume. They're sort of expanding that a little bit now because we're in the digital age. And so now they're starting to measure it more by megabytes. How many megabytes is in your volume? But it's got to be in chronological order. It's sort of a PDF and you file it digitally with the Court of Appeal. Trust me, you can learn how to do this, or you can get a secretary or paralegal or hire an attorney service that does this for you quite capably. But that's the best option. And I'm going to tell you why. Because when you fill out the form designating the record, you just check that box and you're done. And then you've got months as you're writing your appellate brief to be thinking about what do I want to include in the appellate record? Oh, I'm saying this in my brief. I better include that in the appellate record, right? And so the contrast is if you do a clerk's transcript, you have to list in this form all the things you want the clerk to go find. And then later on, after she finds it and sends the clerk's transcript to the Court of Appeal, you're writing your brief and all of a sudden you realize, I should have included this other thing. And now you know what you need to do? You need to file a motion to augment the appellate record. Or I suppose in the alternative, you might do a request for judicial notice in the Court of Appeal, asking them to see this document that you need to win your appeal. Both those options are going to take you a couple hours anyhow. And there's no guarantee. Usually the Court of Appeal will grant that stuff, but sometimes they won't. If they think you took too long, if you didn't convince them you've got a good reason for it, they might deny it. You know what? You don't have to fuss with any of that stuff if you designate an appendix. You're putting your appendix together as you're putting your brief together, and you file them both at the same time. And better still, even if you forget to do it in your original appendix and the respondent files a brief that says, oh, there's some important thing you left out, you can do a reply appendix. You can put it in your reply appendix. It's not like a summary judgment motion where you cannot file evidence with your reply papers. The reason for that in summary judgment is to prevent ambush and surprise. But in an appeal, everybody has already seen this stuff once in the trial court. You're watching this Jaws movie again, for the second time. And so everybody's already seen it. They sort of know what comes. They know the ending. And so you can stick it in your reply brief, your reply appendix. I'm sorry, and file that with your reply brief. So I'm all for an appendix. The other stuff about, reporter's transcript, you just have to tell them the date of the hearing, the department, what the hearing was about. Was it a trial? Was it a dispositive motion? Was it a discovery motion? Whether or not it was previously transcribed, and if so, the name of the court reporter who did it and the department where the hearing was held. And so it's pretty easy to fill out that part of the form. It's got other stuff in there for agreed statements and settled statements that you'll see. Again, because you followed my advice, you won't have to worry about reading any of that stuff. All right, next slide, please, Susie. Okay, so listen, you've done everything right to get your appeal launched and it's floating along out of the harbor, okay? What have you done? Let me run down the list. So far, you've recognized the appealable orders and you've ignored the ones that were not appealable. And so once you recognize the appealable order, you calendared correctly the deadline to file the notice of appeal. At the same time, before then, you took caution and got a court reporter there so that you're going to have a suitable appellate record. And when the case came to the end of the submission, you either asked for a statement of decision and listed the principal controverted issues before it got submitted, if it was a less than 8-day bench trial, or if it was more than 8 days, within 10 days after the tentative ruling, which may have been mislabeled as a statement of decision or a proposed statement of decision, you've in writing requested a statement of decision and listed the principal controverted issues. You've done all this stuff. And then you timely filed a notice of appeal and you've correctly designated the appellate record. Smooth sailing so far, except that you really need to have a little bit of a handle on appellate stays. And listen, because you need to advise your client about how they work and how you're going to deal with it and, the risks and how sometimes you might have to live with or without the stay that, could be good or bad for you. So if you don't understand, plan for, and advise your client about how a stay might impact the appeal, your later conversation when that stay or absence of a stay happens with your client might look like this. Susie, can you play the next clip, please?
Who are you to say anything to me? Who are you to tell me anything? Actually, I really, really do not want to be on this boat with you. I can't move without you moving. Gives me the creeps. You give me the creeps. Can't move without dicky, like a little girl all the time.
Okay, Susie, next slide. Actually, you know what? You and your client are not going to want to be on the same boat. I'd say 99 times out of 100. If the stay goes differently than what you and your client might have thought, and you have to explain that. Susie, could you skip ahead just 3 slides and play the clip there so we can show everybody the Hollywood ending, which maybe it'll happen like this, but I don't think so. Let's see what it might look like.
Bobby. I'm sorry I got you into this. Skip, we made the right call. We had to try. We're so close. Hey, it was a hell of a fight, though. Huh?
Okay, Susie, if you would back us up to slide 29, please. All right, so listen, maybe when you misapprehended how the stay was or was not going to work, and you tell your client about it, he's going to take it like Mark Wahlberg and George Clooney, and well, doggone it, it was a heck of a fight, though, wasn't it? But listen, I'm betting it's going to be more like Jude Law and Matt Damon out there on that little boat alone with no rescue ships in sight. Okay. It's going to be quite unpleasant to ride that appellate wave the rest of the way through. Now, appellate stays, the general rule is everything is automatically stayed, right? Everything is automatically stayed under section 916 of the Code of Civil Procedure. Although section 916 doesn't expressly say it, I'm here to tell you mandatory injunctions are automatically stayed, but prohibitory injunctions are not. And that's probably where it's going to get really tricky about appellate stays. Because a mandatory injunction just basically is often thought of as something that changes the status quo, whereas a prohibitory injunction is something that preserves it. But that gets a little tricky because where do you measure when the status quo was? Was it before the lawsuit? Was it after the lawsuit, but at some point in time when the parties filed some kind of stipulation? Was it after the lawsuit, but when the court issued some kind of preliminary injunction that nobody appealed? Where do you measure the status quo? And what status quo is it that the Court of Appeal really wants to preserve to avoid mooting an appeal? It gets very, very complicated. The California Supreme Court issued a decision called Daly, maybe about 3 years ago. Daly versus, was it San Bernardino, I think. And, it tried to clarify when an injunction is mandatory and when it's prohibitory. And it did help somewhat. I'd say it's still kind of murky. And, they say shark attacks happen in cloudy water. So this is still sort of a cloudy area. You want to get a handle on your appellate stay. Not only, are prohibitory injunctions not automatically stayed, but Susie, can we see the next slide? There are an awful lot of exceptions listed in the statutes. They're all in one place, luckily for you. They're in 917.1 through 917.9 of the Code of Civil Procedure. Money judgments is a classic example. A money judgment is not automatically stayed. So if your client has a judgment against him, her, or it, is for $1 million, and you file your appeal, you might be thinking, whoo, we filed the appeal and now there's not going to be any collection activity. And all of a sudden there's a recorded judgment, there's a till tap, there's a lien, there's a foreclosure, there's a debtor's exam. All these things are happening and your client is saying, wait a minute, I don't even see the shark. Where's it coming from? You're going to be on that boat with Jude Law and Matt Damon, right? You're going to be out there on that boat. And so the truth is a money judgment is only stayed if under section 917.1, the party against whom the judgment is issued posts a bond. And a bond is usually going to be, if you get a surety to do it, 150% of the money judgment. And that money judgment includes the awards of attorney fees. When you're calculating the 150%, it includes, the attorney fees and costs that come after that. Now, there is an exception to this. If you get a judgment that's really just like an injunction or something like that, but then on top of that, there's an award of attorney fees and costs. That's not really a money judgment. There's a money judgment aspect to it, but it's not really a money judgment. And so if it's just purely an award for fees and costs, then that is automatically stayed under 916 of the Code of Civil Procedure, coupled with section 917.1 D, like Daniel, of the Code of Civil Procedure. Okay, so that's one example of something that is automatically stayed. If you look at those statutes, you'll see the different ones that are automatically stayed. That are not automatically stayed without posting a bond. An order that directs the conveyance of real property, an order that directs the conveyance of personal property, stocks, bonds, things like that, cars, boats, what have you. Those also require the posting of a bond. And in those instances, you have to go to the trial court and ask the trial court to fix the amount of the bond. Unlike a money judgment where it's set at 150% of the judgment if you use a surety, these other kinds of judgments and orders require the trial court to fix the amount. And there's lots of different ways to try to do that. So listen, we are near the end of the time. I'm not going to stop right now. I'm going to have a look at the question and answers here and see if there's anything I can answer. Does a notice of ruling along with a copy of the minute order suffice as a notice of entry? Generally, I'm going to say the safe answer would be yes. There may be exceptions. I would definitely treat that as enough to where you really look into it and figure out if you're talking about an appealable order. Just because somebody issues a notice of entry with a minute order, it might not be. A minute orders generally are not appealable unless they really are final. There can be exceptions to whether or not a minute order is a final order. Usually they're not. But listen, if you're getting 60 days past notice of entry of a minute order and a subsequent order that's a real order hasn't come out, I'd say the safer money would be to file a notice of appeal. It might get thrown out later as an appeal from a non-appealable order, but that's a lot easier to fix when you get the appealable order than blowing the deadline. Then there's no, like I said, if you miss the deadline to file your notice of appeal, there's no boat coming to save you. Okay, another question. California has no equivalent to Rule 4A5, allowing 30 days to file a motion for an extension of time, file a notice of appeal. Oh my. Well, that's not a question. That's a statement that a shark is, probably going to eat my boat if I treat it like a federal case instead of a state case. Yes, thank you for pointing that out. That's absolutely right. So listen, I don't see any more questions. I'm going to run down the list and then I'm going to leave you with one little clip at the end just for fun so you can see, all the different ways that your appeal can sink. And so you want to, and Susie, we're going to go back to the clip on slide 4. But before we play it, I'm going to, the one before that, there we go. Before I play it, I'm going to run down the list again. Make sure your appeal is seaworthy by recognizing appealable orders. Spot those appealable orders. Enhance your ability to stay afloat by getting a court reporter. Only use a settled statement if you have to because you forgot to get a court reporter. Reduce the risk of being capsized by getting a statement of decision, and don't just ask for a statement of decision. Do it timely and list the principal controverted issues, even if you think the court has already given you a statement of decision. That's a tentative ruling. Make sure you can leave the harbor by timely filing that notice of appeal. You will be anchored in the harbor if you don't do it. There's no rescue for you if you don't timely file a notice of appeal. Help the appellate court to hear what happened in the trial court and to track the course of your appeal by designating the appellate record properly, and avoid getting torpedoed by misunderstandings about appellate stays. So with that, I'm going to leave you with this last clip that shows how appeals can sink.
Torpedoes 2 and 4. Now, torpedoes on, sir. We're locked on the Akula. You got it, sir.
Okay, that's it. I don't see any further questions. And so I really want to thank you all for joining me. And I want to thank the Beverly Hills Bar Association and Belinda and Susie for helping me launch this presentation.
This concludes today's presentation. Thank you so much, Brendan, for an excellent program, and thank you so much to our audience. Have a great afternoon, everybody.